And then also that you are Christian Mays' mother, and that he is 15 years old, a male, with a birth date of February 3rd, 2005. Is that all correct?
Yes, sir.
Okay. And that you're the person who has care and custody and control of your child?
Yes, sir.
Okay. Well, legal care, custody, and control, right?
Yes, sir.
Okay. All right. Now, Christian, I went over with you with your rights after I swore you in. So you did give up your rights to remain silent, your right to confrontation, your right to a trial. Do you understand that?
Yes, sir.
You also understand that you give up your right to appeal?
Yes, sir.
Okay. All right. And it is also true that your birthday is February 3rd, 2005, and you live in Tarrant County, Texas?
Yes, sir.
Okay. The next question for you is, on or about March 11th, 2020, is it true that you intentionally operated a motor vehicle, specifically an automobile, without the effective consent of Jose Fernando Cruz, the owner of that vehicle? Okay, so I need you to tell me if it was true or not true.
Yes, sir.
Okay, I need the actual words, true or not true.
True.
True. All right, thank you. And you understand that unauthorized use of motor vehicle is a state jail felony, which could result in your confinement at TJJD. You understand that?
Yes, sir.
All right, and also part of the agreement, so you have the parts that don't make you look so good, but also part that you want here is at the end saying that you need rehabilitation and there has to be disposition, and that you agree that disposition should be 12 months of probation, a substance abuse evaluation, and any other condition ordered by the court. You understand?
Yes, sir.
Okay, do you agree with that?
Yes, sir.
Okay, so you're asking me for the probation?
Yes, sir.
Okay. So, Mr. Mays, did anybody force you to say true?
No, sir.
Did anybody induce you to say true? That means, did anybody offer you any kind of bribe to say true?
No, sir.
Okay. Did you say the words, did you say true voluntarily?
No, sir. I mean, yes, sir. Yes, sir.
Okay, all right, that's fine. I know you're probably a little bit nervous, and that's okay. So do you know what the word voluntary means?
Yes, sir.
Okay. Can you tell me in your own words what you think voluntary means?
It means that I said it, like I volunteered to say it.
No, you can't use the word to define the word. I just need you another way to tell me what you think the word voluntary means.
It just means that I said it, that I agreed. I guess it's really, I mean, I know what it means, but I don't really know how to break
Yeah, sometimes it's tricky. Did you do it on your own?
Yes, sir.
Okay. All right. So are you saying true because it is true and for no other reason?
Yes, sir.
All right. All right. Stay wave close.
Yes, Judge.
Respond to wave close.
Yes.
Based on the competent evidence provided at this hearing, the court will make a finding of delinquency. Specifically, the court will find that the allegations in the petition in paragraph 1 was established by the evidence. Mr. Reed, is it the state agrees to waive paragraph 2?
Yes, Judge.
Okay, then the court will accept the waiver of paragraph 2 on this petition. There was no evidence to indicate that there was a deadly weapon used, so the court will make an affirmative finding that there was no deadly weapon. All right, that will conclude the adjudication hearing for this matter. All right, are we ready for disposition?
Yes.
State's ready.
So the court will call cause number 323-113-540-20. This is styled the matter of Christian D'Angelo Mays. We are here with the court having previously adjudicated this child as delinquent. We are now here for disposition. State waive opening?
Yes, Judge.
Okay. Are there exhibits from the state?
Yes, Judge, there are. The state would ask to admit petitioner's exhibit number 1, which is a social history for the respondent, as well as petitioner's exhibit number 2, which would be a victim court report. These items have been tendered to defense counsel prior to the hearing.
Okay. Any objections from the respondent?
I always have the objections of hearsay and the social history, and I understand that they're still admissible. The victim court report is a part of the court record. However, there are some parts of that that we object to as to this respondent.
So what would be the legal objection? The social, well, Ms. Johnson, the social history, I think is required by law for me to have.
Right.
By statute. Now, as far as the victim's court report, what would be the objection?
My objection is the probative value is outweighed by the prejudicial effect. I would also object regarding hearsay, and as to relevance, there is a concern that there is an amount that's being requested in restitution that cannot be attributed to this particular respondent by clear and convincing evidence.
Then, it's a simple question. Is the restitution part of the agreement, the stipulation?
It is not in the stipulation. In all candor to the court, the prosecutor, Ms. Farmer, and I discussed that, and we were going to leave that up to the court because of the problems that we were having with it.
What problems were you all having with it?
It seems that the vehicle was actually stolen several days before my client was involved, and that regarding his involvement, the items that are missing were not in the car. They were not on his person. And he didn't, there was nothing to do with the theft. So the actual theft of the motor vehicle. So restitution is a concern for me in that it may need to be assessed against a different individual other than this respondent.
Mr. Reed, is there any contention that the vehicle was originally taken by somebody else?
Judge, it's my understanding that the restitution is not part of the stipulation, and I think we're dealing with two different questions here. Is the victim report admissible? And per the family code, it is. And then what the court chooses to do with that admissible report is left to the court. So we would just say that the report is admissible. Restitution is not part of the stipulation, but it should be considered by the court per the family code.
Right. Okay. Yeah, I mean, it's admissible, so 1 and 2 are admitted. Mr. Reed, there's no allocution in this?
There's not, Judge.
All right. Ms. Johnson, any exhibits from the respondent?
No, Your Honor.
All right, closings?
Judge, the state would ask that you read the respondent's social history and then ultimately agree with the requirements of the stipulation that the state and respondent's attorney have agreed to. And that's all, Judge.
Ms. Johnson?
Your Honor, we've asked that you follow the stipulation agreement.
So, Ms. Paxson, this is his third UUMD?
Let me look real quick, Your Honor.
Okay.
It is his second.
So, okay.
Mhm.
Mr. Montoya, how many days of work did this victim miss because of his vehicle?
I don't think he told me that. He just told me it was about $520 worth of wages that he lost. So I don't know exactly how many days.
All right. Well, Mr. Mays, how many days did you have this car?
Judge, he actually, this unauthorized use, all the video shows is him having it on the day he was stopped
Right.
at the time.
I
So
understand, but I'm just asking Mr. Mays. How many days?
I'm gonna ask him not to reply because I don't know whether that could constitute a new offense or not.
Okay, he's already waived his Fifth Amendment right by admitting adjudication.
As to this offense,
Yes. As to this offense,
and I don't want him incriminating himself accidentally on some other offense.
so are you aware of an offense that he would incriminate himself on?
No, but I don't want to run the risk either.
Okay, so, I mean, you can only invoke the Fifth if it's an actual offense that you think has been committed that would implicate oneself. You can't invoke the Fifth on a hypothetical you don't know. So, I mean, if you're invoking the Fifth Amendment, then that's fine. I understand. But the law doesn't allow to invoke the Fifth on something that's uncertain.
Well, you're asking him about a different offense and a different date.
I am asking him on this unauthorized use of a motor vehicle, right? How many days he had that vehicle?
The
I
day
mean, he's already admitted to
right,
this
the day
offense.
he had it.
Well, I mean, Mr. Johnson, I'm trying to get information to do what's right. Now, well, okay.
My concern is there was an offense committed that involves the same vehicle days before my client was involved.
Okay, no, I understand. All right, so then what I'll do is on the court's own motion, we'll grant a new trial and the court will remove the finding or abate the finding of delinquency for this child on the adjudication. And then,
Judge, I would ask that you not do that. I mean, he's agreed to that. He understands all of that. And if he'd like to go forward and answer this question, he can. I just need him to understand that I don't want him incriminating himself. And I don't know that he would. Honestly, I don't know.
right. Well, I mean, there's monetary loss here. There's a duty by the court to find when restitution is appropriate. I don't want to assess him the entire restitution amount because I don't think that's appropriate. But if I can't do what I think is fair, then I have to leave it for the district attorney to decide or a jury to decide.
Let me ask him, do you have any problem with answering the judge's question?
No, man.
Okay. He will answer your question.
All right. So, Mr. Mays, how long did you have this car?
The day that I was on camera, it's the first time I ever hopped in the car or seen the car.
You said on campus?
On the camera.
Okay. You know more about this than I do. What camera are we talking about?
I'm talking about the camera where I was in.
There was video surveillance at the mall.
Well then, okay, this doesn't make sense. So the first time you ever saw the car was at the mall.
No. That's it.
So when did you first get this car?
I never got the car. It's just like, it was my first time ever being in the car.
Are you telling the judge that the day that you were stopped and arrested for this was the day that you found the car or was in the car?
Yeah, that's the day I was in the car.
So let me be clear. Are you telling the judge that you had this car for a day?
Yes, ma'am.
That's what he's asking you. Okay.
Mr. Montoya, when was this car, like we don't know how long the car was gone, right?
Well, I was just looking at the police report. The car was reported stolen on March the 8th, and the offense occurred for this juvenile was on March the 11th. So I'm approximately 3 days. And it seems that the victim picked up the vehicle, retrieved the vehicle on the 11th, on the day of the offense.
So who gave you the car?
Did you find the car? Was it some friend of yours? That's what the judge is asking you.
How did you get the car?
From a friend.
Okay, who?
I don't know nickname. I don't know his legal name.
I'm sorry?
I don't know nickname. I don't know legal name.
I don't understand what you're saying. Can you enunciate?
I said I only know his nickname. I don't know his full government name.
You only know him by a nickname. You don't know his real name. Is that what you're saying?
No, he's saying he doesn't even know the nickname.
No, he said he knows him by nickname.
Okay, so who was it?
I really not say.
You sure you want to go down this road? I mean, if it's up to you, like, if you're telling me you just rather not say, then, yeah, I mean, I'll respect that, but I mean, right now you're trying to tell, let me explain this something to you, Mr. Mays. We're here right now because you're saying you're a child that needs rehabilitation and you're trying to do the right thing and trying to set your life on the right path. And part of that is openly admitting to what you did and your involvement so we can find out the best way to supervise you so you don't continue to make poor decisions. If you're telling me right now that you're not even willing to accept full responsibility for what happened, then that tells me a lot of information as well. So that being said, because you have to remember this whole time you're being supervised by our probation department, you're going to have to be openly honest and forthcoming. And so if you're telling me now that you're going to keep secrets and you're not going to be open about everything, well, I mean, that changes the type of probation you get or the result of this case. So that being said, if that's your decision, I'll respect your decision. But I need to know that you're going to put up walls and you're not really going to accept full supervision.
It's just me. I fear for my life. I don't feel comfortable saying someone
Can you
else.
repeat that? Our court reporter doesn't understand what you said.
I fear for my life because I don't feel comfortable saying someone's name and they come back for me.
Okay. Ms. Johnson, I don't think your client's a good candidate for probation. I mean, if he can't admit his involvement in a criminal act, then that's not.
Well, he's admitting his involvement, Judge. He's just concerned, I think, about involving somebody else in a criminal act. And he doesn't want to say the name. So if he would like to say the person's nickname to the court, that's fine. But he's admitted his involvement. He's never wavered on that.
No, part of Ms. Johnson, part of his involvement is how he acquired the instrument of criminality. I mean, that's just, you and I both know that's just, I understand your argument, but I mean, that's part of it. It's from start to finish on what every part that he did wrong. That's just part of rehabilitation. But if he's not going to recognize that, that this is just part of probation, I can't expect him to be forthcoming on the rest of the stuff. I just don't see it. And I'm willing to accept it and do the 1-year probation, but he has to be he has to be 100% transparent with our probation department. And he's not willing to.
Are you willing to give the nickname of the person where you got the car? I think is what the judge is asking you.
No, I want their real name. I mean, he has to own up to it. These are the people he's hanging out with. These are the people that we have to make sure he doesn't associate with.
I don't know his real name. I don't even know.
Do you know his nickname, even if you don't know his real full name?
Yes, ma'am.
Okay. Is his nickname something that you're willing to give the judge now? I mean, if you know it.
His nickname is K.
K?
Yeah. We always call him Lil K.
No, I'm not satisfied with this one. I don't think it's appropriate for the court to accept this stipulation. Now, I'm not busting it. I mean, I'm not rejecting it. I'm just saying this child, because honestly, at this point, one of the conditions of probation is going to be disclose the actual names of the people that he was with, right? And here's the problem. Here's a
police report with the actual names of the other people he was with this
Mr.
day.
Mays, is he the one that you got the car from?
Yes, sir.
Which one?
K. I know him by. That's the only person I knew in the car.
The police report lists 4 people. So, I mean, the names are on there. If he was ordered to stay away from the 4 people that were in the police report, that would cover them all, even if his nickname was K, I would think. The court could just order him to stay away from all of them.
Ms. Johnson, I have to draw a line somewhere. I mean, this is a child that's not willing to admit his complete involvement in an offense. That's where probation starts. We can't even start rehabilitation if he's not going to be forthcoming at the disposition hearing, right?
However, if he doesn't know the person's legal name, I mean, we know nicknames of people and don't know their government names. That's not as unusual as it might sound. And if he's ordered to stay away from everybody that was involved in the original response, that would take care of that, because I think that would be appropriate. He doesn't need to be around them. And I think his mother agrees with that.
Ms. Johnson, the problem is, at this point, he's still engaging in criminal thinking. He's still trying to protect other people. When he says, I'd rather not give up the name, they're not involved, I'm owning up to what I did. I mean, this is the core of criminal thinking. I mean, even if I put the names out there, this shows me at the very first day, even before he's assessed probation, he's telling me that he's going to withhold information. And this is not a good candidate for probation, not at this point. If he wants to come back and be forthcoming about it, I have no problem. But if he's going to put up walls and hide things from the court and from probation, we're wasting our time on probation. Especially this, and this is his second UUMV. He didn't learn the first time Now he's coming. I think you did a great job, Ms. Johnson. I mean, I'll be completely candid. I think you're doing a fantastic job for your client, but I don't think your client. I think the court is wasting its time. The court is wasting its time with your client because he is not willing to accept supervision. So, I mean, maybe I went ahead and made the docket entry that I vacated the adjudication, right, and on the new trial, and then go back to the drawing board. But I suggest that if we come back on a different day and you can come up with another agreement, that we do it where your client understands if he's taking probation, he's taking probation, right? He's not just stalling or kicking the can down the road. But I mean, I expect respondents to be absolutely candid and open with the court, especially if they can get supervision. So at this point, granted the new trial, I vacated the adjudication. So we're back to square one. And then, Ms. Johnson, you schedule have more conversation with Mr. Reed, but I hope you understand the position I'm coming from. And when he's telling me that he doesn't want to be a snitch, that tells me that he's still willing to hide things. That tells me this probation's not going to work out. All right. So I'm not rejecting the plea because I don't think it's fair. I'm saying this kid is just not going to be forthcoming. And so, Ms. Johnson, here's the thing, right? Let's say we finish off with this probation. Part of the stipulation is any other condition that the court places on this child. One of the first conditions that's going to be is to disclose to the court who he obtained the car from. If he's not willing to do it now, he's not going to be able to do it after disposition, which means he's already violated his probation.
Well, you asked him, he answered it. And now, I mean, I understand that you have a concern with his answer, but he did answer your question. And if he doesn't know all the information, I don't know how you're going to make him know it.
Well, that's the thing is earlier he said he knew, he just didn't feel comfortable disclosing it.
Yeah, he didn't want to say his friend's name was K or little K or whatever he said.
No, I understand. So,
but he did answer the judge's question, the court's question when asked, do you want to tell me who it is? He did.
All right. So, well, I mean,
I'd still ask the court to follow the plea agreement.
this. Now, I'm gonna go and leave this. I already made the finding. We can reset this, Ms. Johnson. If your client is willing to be 100% forthcoming when we do this again, I'm okay. I don't have an objection to the deal itself. I don't have objection to the probation or the terms. I wish there was more clarity in restitution. That's just me. That's not on you two. But for him to, really for somebody to come before the court on a stipulation and then say, I'm not comfortable giving this information, that really gives me a lot of heartburn, right? It's really hard to, even before you start probation, to tell the court you're not going to be transparent and fully disclose the information that you have that's needed. So,
can I request a quick conference with my client before you do that?
Well, I've already made the docket entry.
Oh, you've already made the docket entry. That's right.
So I have. Technically, the first time I said I made the finding, I think I made the finding. So I think we have to go back to adjudication anyways, since I made the finding on the record. But this, I feel like now there's like kind of a weird pressure on your client to say things he may not want to say. I respect his decision, right? I mean, don't get me wrong, Mr. Mays. I'm not saying I don't respect your decision to do what you think is right, to follow your moral compass. That's not the problem here. The problem here is, if that is your decision, does that mean you're good for probation or not? Okay. I'll respect your decision, but every decision has consequences. Okay. And that's just where we're at now. I'm not trying to beat you up or anything. Your attorney's trying hard, but we're just at the point now where, knowing that you don't want to disclose everything to the court, which means to probation, which is an extension of the court, I don't want to see you back here in a week on a probation violation and then send you to TJJD. That would do you a disservice. Okay? So All right, so that will conclude today's adjudication disability. I did make a docket entry that the court on its own motion grants a new trial and vacates the adjudication. And since we've done that, there's no reason to conclude the disposition hearing. Okay. All right, thank you, everyone.
I guess we can walk out and just wait and see what this.
Judge, are you still available? I do have some housekeeping for this morning's docket.
Yeah, I'm here. What do you got?
There was a setting on a respondent named Leroy McReynolds at 8:30. That case has been dismissed.
Oh, good.
There is also a setting for a Jeremiah Teeler. It's my understanding that that respondent has never made an appearance. Doug Ligon was of the opinion that he was not going to make an appearance. And even if he did, we would have to pass it so he could do basically intake with JPD. So I saw that the Jeremiah Teeler was set, but I don't think there's anything to be done on that today.
So the case has been filed. Has he been served?
Judge, I don't know how to access that information. I mean, typically I just go ask Mary.
Right.
I'm not aware, but I could find out.
Okay. But the petition is filed because that's a case number. Well, let's see. I have the jacket here. Okay, has not been served yet. All right, so now we're approaching 4 months where the child hasn't been served yet. So I'll get with Mr. Ligon so we can make sure that child is served. Okay. All right.
And I believe that's all my settings for this morning. So may I be excused?
Yes. Have a great weekend.
Thanks, Judge. You too.
Sorry, but am I off base on this one? On the?
No.
Okay.
I think Carmen, I would probably, if a judge was questioning about prior activity, it would raise a red flag for me. But ultimately, I think you're right. If it's part of the stipulation is to follow any conditions, well, that stipulation could be anything the court wanted. So if you wanted to ultimately know where'd you get the vehicle, and his first gut instinct is to say, I'm not telling you, well, that's probably a good indication that he's not going to be compliant with probation. So yeah, I agree. I'll let Ms. Farmer know. I'm sure we'll be back and there will be a different attitude in the near future.
I think that will be, hopefully that's my goal, so that when it comes back, because you're not going to change your offer. I mean, the 1 year probations, it's a good offer both ways. But I think if we can do this again, he comes back forthcoming, it actually teaches them, hey, probation is something serious. Otherwise, he's going to spend his whole time trying to smoke pot around our drug tests and sneak out when he's not caught. And, I think it goes back to that criminal thinking. Oh, well.
Yeah.
Yeah, Ed and Kelly here, they're laughing. But for me, I'm just like, I don't even know what to do. So, oh, well. Happy Friday, everyone.
Yeah. Thanks, Judge.
Thank you, Mr. Reed.